Hey all, welcome back to the Law Read Slowly. So in the last session we were writing about plaint. We had written about what is a plaint in briefly. I also made to write about how is a plaint different from a suit. We had also written about affidavits and verification in terms of pleadings. That is, when you attach your affidavit and your verification with the pleading, what does it mean? What effect does it have? What consequence does it have for the pleading? And how it completes the pleading. I will not go into repetition of all of that. I believe we have discussed it at length in the past few sessions and it should be very clear to you by now. We also wrote different cases that we require in completing this discussion. We wrote from the case of Salem Advocates. We wrote from the case of GM Siddeshwar versus Prasanna Kumar. We also wrote from the XVIII case. We also wrote from All India Reporter case. And we discussed different positions that the high courts have laid down. What has the Supreme Court said? We also discussed the Supreme Court's caution against stringent approach in examining the pleadings, because rejecting a pleading is always going to lead to denial of justice in some manner, the court says. Hence, you should not always be quick to throw out the pleadings at the very threshold. Rather, take a more lenient and justice-oriented approach, the Honorable Court says, and give the party maybe one chance or two chances to rectify the shortcoming in their pleadings, and then consider their pleadings and take them on the record. So that was a discussion that we had completed. We also, I discussed with you the general tilt of the court in accepting affidavits in the evidence stage of a trial in civil procedure. How it depends also on the nature of evidence that the witness has come to give. If the evidence that the witness has come to give is of a more formal nature, then affidavit sounds like a better option to go for, because anyways you can prove that particular fact set by additional circumstantial evidences in the case, and then your testimony of that witness is going to only provide the support to what can already be proven. Hence, an affidavit doesn't sound very out there. But when the testimony of a witness is supposed to be very subjective, that is based on his memory, based on what he saw, based on what he heard, then there you have a lot of subjective facts that will be argued upon. There you would prefer that you have the witness in the courtroom giving that testimony, so the parties present and the honorable judge present can hear the person in real time and take note of his demeanor, take down the different points that he's making, cross-examine him then and there. So all of those points we have discussed, we have also written about them. Today we will write more about them, because I believe in the last session we wrote about usage of affidavit and verification in terms of pleadings. Today I will make you write about where you spot affidavits in other arenas. We have discussed this at length. It was just that I had to make you write about it. So we will write about how we spot affidavits in general scheme of things, like a name change application, all of that kind of things. And we also spot affidavit in another place where we have discussed in evidences. We've discussed it at length. We discussed the whole framework behind Order 18, Rule 4, Order 19, we will also read a section today, Section 30. Which is corresponding section. I told you every order might or might not have a corresponding section. So for your Order 19 and your Order 18, Rule 4, you can say the corresponding section will be Section 30, Clause C. We'll read it before we begin writing today. So we will write about that, and then I will also make you write something from the Salem Advocates case. I told you that the counsel in that case, before the 2002 judgment, had raised this point of concern that if you are allowing affidavits to come in at the evidence stage, what does it mean for the quality of evidence, for the proof of evidence? How do you prove it? Are you saying that anything that is being accompanied by an affidavit automatically becomes proven for the purposes of Indian Evidence Act? Because then we had Indian Evidence Act and today Bharatiya Saksha Adhiniyam. Or is there a different import, connotation or inference that needs to be drawn from allowing an affidavit to be submitted in terms of examination in chief? The court clarified it there, that we are not saying that merely filing your affidavit will mean that whatever is written in that affidavit is true. It is only meaning that whatever I as a party have written in my affidavit is true from my side. It will not be taken to be proved for the matter of the case. Definition of proved is given in Indian Evidence Act and in Bharatiya Sakshya Adhiniyam. It will not be proved. It is only a testament on behalf of the person, the deponent signing the affidavit, that I am not lying. That is what an affidavit is. And I will make you write a quotation or maybe paraphrased version of that from the 2002 judgment, and that will complete your notes also. And so let me give you also a roadmap of what we're going to do. So we will finish this discussion on plaint, and so far we have discussed a couple of things which we will recap and see where we are standing now after like good, I believe it's 11 or 12 sessions so far we have had. So what have we done in 12 sessions? What have we covered? Do you feel strong enough compared to your older self before session 1? Where do we stand now? And what we'll be doing after that. So I want to complete. So this is like, so I told you that I will give you a weaponry, this categorizations. So I discussed the framework of the whole suit. You can call it a title to your weaponry, and then your categories and different stacks in which you keep your weapons for CPC. These are your weapons. So when we discussed plaint, we discussed verification, we discussed affidavit. We will come back to plaint maybe once more throughout this course and do more detailed discussion on it, because there are certain rules in Order 7 that I have to discuss with you more elaborately. We'll do all of that. And then we will move on to discuss, we'll do it logically. Then I'll take you to brief introduction into what is a written statement. Probably I'll tell you how do you write it, like I told you for the plaint. And a few other terms I'll tell you about, and then from there I also want to tell you some more important terms which we will encounter across this series. So there are different terms. Cause of action I've already discussed and finished with you. Just like cause of action, there are other terms, so they are all appearing in your pleadings only. So cause of action, I mentioned subject matter. What is a subject matter? I mentioned matters and issue when I was telling you plaint. So I want to open things as I'm mentioning them. So all of these things will be set in your mind, because these are flyaway terms you can call, because they keep coming in at different junctures in CPC. So any discussion on CPC that you're having, these terms will show up. So I need you to know the meaning of these terms already. So when we're doing an elaborate deep discussion on a topic and I mention something out of these terms, then you should be able to grasp the full import of that term, so that you are able to understand the actual topic that we're discussing. Because if I don't tell you the meaning of these terms now, and then when I'm discussing some deeply and rooted discussion in the Bare Act, and these terms show up, you will get stuck on the term itself instead of focusing on the larger topic that we're discussing. So I want to tell you the meaning of these terms and these concepts and get it out of the way early on, so you are completely ready to tackle the bigger topics then. Clear? So let's do this. Let's begin writing. I will most probably finish all your writing, dictation and articulation of your written notes in this session with respect to plaint and related discussion on affidavits and everything. And then next trajectory, we will move into discussion on written statement. Then I have to tell you replication, rejoinder, all of those we have discussed when we were discussing trajectory of a suit, but I have to discuss it properly to close them up so that the meaning gets stuck in your mind properly. And then we will also take an interesting fact situation. We will probably pick up the same fact situation that we used for the plaint, and I'll tell you how will you do a written statement on it, so you have an idea properly as to what goes into a written statement. Clear? And after that, I will move into some more terms. There we will take tons of examples, because those are very important terms and they're often such terms which end up confusing a lot of students. Like, what is a relief exactly? What is subject matter? What is matter and issue? Because matter and issue is a term which is used in one of the most important provisions in CPC. If you see res judicata, there they say matters directly and substantially in issue. But if you don't know what is matters and issue, then you will not be able to understand the provision itself. So I have to explain to you all these different terms, and we will take so many examples, and then we will progress into the next topic from there. I will probably either take you to discussion on Order 1, which is about parties to the suit, or I will take you from the section side of things. We can either go into jurisdiction or parties, because I want to move logically as to what comes first in the trajectory of a suit. So first you can either decide the jurisdiction where you're going to file the case, or you can talk about against whom you're going to file the case, who will become a party to that suit. So it's up to us how organically you want to pursue this discussion. Accordingly we'll proceed. So now I would just start writing. Let me also pull up the judgment on my screen, which I will use for today's dictation. Okay, so let me give you a small intro to write first, and then from there we will move into further stuff. So begin writing. So first, this dictation is on affidavit. How do you spot it in different walks of life? We have discussed how you spot it in pleadings with provisions and everything. Before we start, I told you we will write about affidavits in evidence stage also. I want to make you read section 30, subsection C, clause C once. I think I've read it for you before. But once again, before we begin, I want this to be in your mind. Come to section 30 of CPC. Power to order discovery and the like. Subject to such conditions and limitations as may be prescribed, the court may, it's a discretionary provision, at any time, either of its own motion or on application of any party, do what? Come to clause C. Order any fact to be proved by affidavit. So they can use an affidavit to prove any fact. Clear? So here when they're saying prove any fact by affidavit, it's linking to Order 19, because this was existent already from 1908 onwards. And your Order 18 Rule 4 has come later on by an amendment. So when this section 30th clause C was written, what order was it making a reference to? It was making a reference to Order 19, because at that time you only had Order 19 which was dealing with affidavits, right? Come to Order 19 now. We have read this, but I want to show you something because we will write about it today. We have discussed this. Rule 1. Any court may at any time for sufficient reason order that any particular fact or facts may be proved by affidavit. So here when it is saying proved, here it is saying in the sense of Indian Evidence Act. Why? Because here they are giving you, allowing the court to also get the cross-examination done by affidavit. So what does proving of a statement require? That you do examination in chief, you do cross-examination, and you do re-examination. Section 137 Indian Evidence Act, 142 BSA. 3 things are required before you can declare that the statement is proven. Here when they are writing proved, that is what they are allowing the court to do, because here nowhere they are saying that only examination in chief can be allowed on affidavit or only cross-examination can be allowed on affidavit. It is just saying proved. So here, since they are only using the word proved, examination in chief, cross-examination and re-examination fall within its purview. So Order 19 Rule 1 is giving the court discretion to do proving of the fact by affidavit. How will it do? Court can tell the plaintiff that do your examination in chief for your witness. It can tell the defendant also if it's defendant's witness. Let's take plaintiff's witness as an example. So suppose plaintiff wants to bring in a witness, court will tell them make your witness give his examination in chief on affidavit, then ask the defendant to do your cross-examination on affidavit. If plaintiff wants to do a re-examination, tell the plaintiff that you do your re-examination on an affidavit. So it can get a fact proved by affidavit, but it's a discretionary power. But on the other hand, if you come to Order 18 Rule 4, in every case the examination in chief, see here they are mentioning only examination in chief, of a witness shall be, it's required, it's mandatory, on affidavit, and copies thereof shall be supplied to the opposite party by the party who calls him for the evidence. Now here if you come to sub-rule 2 of Rule 4, it says the evidence. When does something become an evidence? After it has passed through different stages of testing as provided in BSA or Indian Evidence Act. What is the stages of testing for a testimony? Examination in chief, cross-examination, re-examination. After all these 3 processes are done, which will try to break down that statement, and still the statement survives, then it becomes an evidence. The evidence, which is cross-examination, re-examination of the witness in attendance, whose evidence? Examination in chief. So here what they're saying, that your cross-examination, re-examination is being done in the court. Examination in chief was done on affidavit, whose evidence, that is examination in chief, by affidavit has been furnished to the court shall be taken either by the court or the commissioner appointed by it. Clear? So here they are nowhere talking about allowing cross-examination or re-examination by affidavit. They are very clear. Although they are saying that the word evidence includes all three, that is why they have specifically mentioned that when first time we are using evidence, we only mean cross-examination and re-examination, which is to be done in the court. When we say evidence in the second time on affidavit, they are in brackets, they are mentioning examination in chief. So examination in chief is mandatory to be done on affidavit. But for that also we have discussed that there is a leeway provided in Salem Advocate's interpretation of the law. And your cross-examination and re-examination is not to be done on the affidavit mandatorily. It needs to be done in the courtroom. But Order 19 Rule 1 can be used by the court to get it done on affidavit if they want to.